Welcome to another video and to a new case. Today's case is about a man who was a lawyer and a husband. He did something so filthy and disgusting to 11 women that it is still considered the most bastardly and treacherous act in Canadian history. The most vile part is that he did all of this knowingly and with full intent. Today's strange and disgusting case is about Johnson Aziga. How his habit of hiding his own shame destroyed the 11 lives of women in a way that no one in history could have ever imagined or understood. Without wasting any further time, let's go into the case. But before we do, I request you to subscribe if you haven't already. Johnson was born in 1956, a Ugandan-born Canadian man formerly residing in Hamilton, Ontario, notable as the first person to be charged and convicted of first-degree murder in Canada for spreading HIV. After two women he had infected without their knowledge died. He was known as an educated and sociable man within his community. He attended the University of Guelph, where he met his future wife. The couple married and had children, 3 of them. His life outside of work, including his social circles and personal relationships before 1996, remains largely undocumented. What we do know is that he met many of the individuals involved in this case at bars and clubs in Hamilton area. But the nature of his social life and personal relationships before his HIV diagnosis is not elaborated or documented further upon. Aziga came to Canada as a refugee in 1990. He wasn't just an immigrant, he was granted refugee status. He arrived in a new country, built a life from scratch, got an education, secured a job. Post-separation, Aziga became distant from his children and engaged in a contentious process over child support. So by the late 1990s, the picture had already started to fracture. The marriage was over, the relationship with his children was deteriorating. He was fighting over child support, and he was HIV positive, a diagnosis he was carrying completely alone in his social life, telling almost no one. Evidence would later show that Aziga knew in January 1997 he had tested positive for a strain of HIV rarely found in North America, but failed to tell his partners. So in the early days, he did the right thing, at least within his marriage. His wife knew he used protection. Following his diagnosis, Aziga received counseling and information on safe intercourse practices from a medical professional. Despite this, he chose to engage in unprotected sexual encounters with multiple women. Aziga was born with cryptochildism, a condition where one or both testicles fail to descend into the scrotum before birth. In his case, one testicle never descended. When courts later asked him why he had spent years infecting women with a lethal virus without telling them, this is what he pointed to. His forensic psychiatrist, Dr. Philip Klassen, later testified that during 9 hours of interviews with Aziga, he reported that Aziga placed a great deal of weight on this physical abnormality as the root of explanation for his behavior. The deformative testicle case, according to Aziga, had created a lifelong habit of hiding information about his own body. He felt shame about it. He was embarrassed. He'd kept it secret his whole life. And that pattern of sexual secrecy, he argued, is what made it impossible for him to disclose his HIV status either. What makes this even more striking is that the secrecy wasn't performance for the courtroom. According to the testimony, even his ex-wife and longtime girlfriend had no idea about this physical condition. He had hidden it from the people closest to him for decades. He said he didn't disclose his HIV status because of sociological and ethnocultural barriers, religions, and taboos. He also blamed depression, financial problems, loneliness, migraines, alcohol, and the fact that, as he told the court, there is no word for penis in his native language. The deformative: after the dissolution of his 10-year marriage in 1998, he dated several women that he met through his work as a research analyst with the Ontario government, and others that he met in bars in Hamilton. The post-divorce period is where the story really begins. The marriage ends, the guard comes down, and the consequences starts to build, quietly, invisibly, and lethally, from the woman who had no idea who they were dealing with. Between the spring of 2000s and the fall of 2003, Aziga had unprotected intercourse with 11 women without disclosing his HIV status. That's 4 years between his diagnosis diagnosis, and when the pattern of crimes began, 4 years of knowing, of being counseled, of understanding exactly what he was carrying and what it could do, and then choosing repeatedly to say nothing. The appeal court later summarized it plainly that Aziga deceived these women for his own sexual gratification as part of a repeated pattern of conduct, being fully aware that he was putting his and their lives at serious risk. After refusing to take measures to reduce the danger he posed because of concerns for his own health, the protection of his partners were never the calculation, his own comfort was. According to court records, he was sexually active with 50 to 100 women, nearly all of them white, and admitted to having unprotected intercourse with at least 11 of them without informing them about his condition. The 11 women in the charges were not the full extent of his sexual activity. Actual number of women he slept with during this period is dramatically higher, and how many the others may have been exposed but never tested or never came forward is simply unknown. In an audio tape interview before her death, one woman insisted she would not have had intercourse with Aziga had she known of his condition. She described being in a 7-month relationship with Aziga after meeting him at work in the fall of 2001. He met women in professional settings too. He was charming, educated, and socially confident. She described him as a very nice and considerate person and then said they had intercourse. There was no discussion whatsoever about his HIV condition at all. It was all unprotected. He was repeatedly advised at an immunity clinic about the risk of transmission through unprotected intercourse and the risks of AIDS. He took medication to maintain his own health but declined antiretroviral therapy to reduce his contagiousness due to the bulky pills, potential side effects, and confidentiality concerns. So he was taking medication, but specifically the medication that would have reduced his viral load and made him significantly less likely to pass the virus to his partners. He declined that kind of medication. He was ordered in 2002 under the Health Protection and Promotion Act to refrain from unprotected intercourse without disclosing his condition to his partner, but repeatedly he breached it. In 2003, he was served with a court order with essentially the same conditions. By 2002, the Canadian public health system had formally intervened. This wasn't an informal conversation with a nurse anymore. This was a legal order, the Health Protection and Promotion Act, telling him in explicit terms what he was required to disclose his condition, wear protection during sexual activity, and provide the names of his sexual partners, but he failed to do any of those. And then, when a second order was issued in 2003 with essentially the same conditions, among the first admissions made in trial proceedings were claims by Aziga's former girlfriends that he had lied about his HIV condition and continued having unprotected intercourse until the morning of his arrest in 2003. 7 out of 11 women were infected, meaning his viral load was active and his ability to transmit the virus was significantly higher than it would have been on proper treatment. The 2 women who had died didn't die quietly. One woman's passing occurred in December 2003, less than 6 months after Aziga's arrest. The second death followed in May 2004. Both deaths emphasized the rapid and devastating progression of the disease in individuals whose infections went undetected and untreated. These women didn't know they were infected. They weren't getting treatment. By the time they found out the disease had already progressed significantly in some of their bodies, they can't do anything. A research scientist with the Public Health of Canada National HIV Laboratory testified that the victims shared the same clade A strain of HIV as Aziga, rare in Canada, but considered endemic in Uganda, the country from which Aziga had migrated. The strain was distinctive. It traced back specifically to him. On August 30, 2003, Aziga was arrested by Hamilton police outside his Bay Street North townhouse. He threw his keys at a uniformed officer in anger. Police executed search warrants at the Ministry of Health address in Toronto where blood samples of Aziga and some of his victims were stored. Aziga's case was further complicated by allegations that public health authorities and law enforcement had been aware of his condition for years but took no immediate action. Their failure to intervene earlier has been a source of significant controversy in Canadian public health and legal circles. The arrest happened in 2003. The crime started in 2000s. The public health order came in 2002. At what point did authorities know enough to stop him? and why didn't they move faster? Even after his arrest, Aziga's relationship with accountability was complicated at best. He told the court that he had not deliberately infected women, and he maintained that position for years. He admitted he had unprotected intercourse with the woman without disclosing his illness, but maintained he couldn't know for sure that he was the one who infected them. The appeal court cut through that framing directly, describing his behavior as disgraceful, self-regarding conduct, in which he was fully aware that he was putting their lives and health at serious risk. The court was not interested in the distinction he was trying to draw, and neither ultimately was the jury. While he was married, he appeared to follow the rules. He disclosed his HIV status to his wife. The household knew, but once the structure collapsed, whatever constraint had been holding his behavior in place went with it. Aziga learned in 1996 that he had contracted the virus that caused AIDS and felt like he had been shot in the head, heart, and soul. At the time, HIV was regarded as a death sentence. He said that the social stigma he faced caused him to sink into a deep depression. But what he did with that information is a different matter entirely. The prosecution argued that Aziga, aware of his HIV-positive diagnosis since January 1996, intentionally withheld this information while engaging in unprotected sexual intercourse with a woman between June 2000 and August 2003, forcibly causing grievous bodily harm and, in 2 instances, death. In October 2002, a newly diagnosed woman named Aziga as a recent sexual contact. A woman who had been recently diagnosed, going back through her contact history and putting his name down. Public health authorities were now aware, and Aziga was ordered to practice safe intercourse under Section 22 of Ontario's Health Protection Act. In March 2003, another newly diagnosed woman, also named Aziga, as a recent sexual contact. Now, 2 separate women diagnosed months apart had independently identified him. When he was arrested in 2003, he was 47 and living in Hamilton on Bay Street North. Police had placed him under surveillance and executed the arrest outside his townhouse. At this point, the 2 women who would eventually anchor the murder charges were still alive. One of the women, known as SB, died in December 2003 at the age of 51 as a result of lymphoma that was diagnosed in 2001. However, she was not tested for HIV until July 2002. She claimed that Aziga infected her with HIV during the summer of 2000, 2 years between infection and test, another year and a half before she died. By the time she knew what was happening inside her body, the disease had already been there long enough to trigger cancer. The second formal sexual partner of Aziga to die, known as HC, dated Aziga for a year from October 2001. She was diagnosed HIV positive in November 2002, began therapy a year later. But in April 2004, she was diagnosed with lymphoma and died in May 2004. She began treatment, but not soon enough. The disease had moved faster than the intervention. On November 16, 2005, Justice Norman Bennett of Hamilton ruled there was sufficient evidence for Aziga to stand trial. His trial date was initially set for May 2007, but was moved back several times. The trial was set to begin October 6, 2008. Aziga, who had been in prison since his arrest in August 2003, went through 6 defense teams, delaying his trial, which finally began in October 2008. Each change in counsel triggered delays. Each delay pushed the trial back further. Whether this was a deliberate legal strategy, genuine difficulty finding representation, the result was that the families of 2 women who had already died were waiting years for a courtroom to even begin addressing what had happened. Superior Court Justice Thomas Lofchick rejected a request by Aziga to postpone the trial again so that he could be represented by criminal lawyer Greg Leslie. The lawyer had a heavy caseload and was unavailable to assist Aziga's primary counsel, Davis Bagambri, until 2009 August. Instead, another Toronto lawyer, Munyonziu Hamalingua, agreed to step in and help defend Aziga. The defense wanted jurors screened on whether their ability to judge the evidence would be affected by the fact that the individual charged was a black Canadian citizen who was born in Uganda with HIV, and the alleged victims, including the 2 deceased women, were white. The racial and HIV stigma dimensions of the case were already present, and the defense was trying to surface them before the trial even began. The trial, which lasted 6 months, concluded when a 9-man, 3-woman jury found Johnson Aziga, 52 years old, guilty of 2 counts of first-degree murder, 10 counts of aggravated sexual assault, and 1 of attempted aggravated sexual assault after deliberating for 3 days. The jury heard from all 11 women, some in person, some through pre-recorded video and audio testimony because they were no longer alive to take the stand, 7 of whom believed that Aziga had infected them with HIV, including pre-recorded video and audio testimony from the 2 women who had died. Both claimed that Aziga had not disclosed his HIV status to them before having intercourse, and that they would not have had intercourse with him had he done so. Although Aziga's defense team raised doubts over the origin of HIV in these women and several others who had other sexual partners in the same sexual network and who may have also shared similar strain of subtype A, the jury believed the testimony of Dr. Paul, director of a public health agency of Canada's National HIV Laboratory, who concluded that only Aziga could have infected the 7 women who were HIV positive. At the 2009 trial, Crown prosecutor Karen Shea argued that Aziga's intent was reflected in repeated lies to his sexual partners about his HIV status, even when he learned that some of the women were sick, and after Hamilton public health officials told him he had infected 3 partners, he didn't comply with them. On April 4, 2009, Aziga was found guilty at Hamilton Superior Court. Aziga was sentenced to life imprisonment with no possibility of parole for 25 years, the mandatory sentence in Canada for a conviction of first-degree murder. The murder conviction resolved the criminal liability question. The dangerous offender hearing was about something different. It was about whether Aziga could ever be trusted to walk free again. Aziga's dangerous offender hearing commenced May 10, 2011 to determine whether or not he would be classified as a dangerous offender. Expert evidence was heard from Dr. Philip. Aziga took the stand. He read a statement expressing remorse. He said he was sorry for what happened, carefully worded language that his own lawyers had to clarify afterward. Aziga said that his arrest saved him as well as his partners because some went from testing once they heard that he had been arrested. He had not deliberately infected those women. Even in the apology, there was the qualifier. Even standing in front of the court, he couldn't fully say it plainly. During weeks-long hearing, where final arguments were heard in late June, the Crown said that Aziga should be labeled as a dangerous offender because his abnormality, high libido, could lead him to reoffend. Justice Thomas granted the Crown's request to have Aziga declared as a dangerous offender. Aziga believed to be the first person in Canada convicted of murder through the spread of HIV. After the ruling came down, a disturbed Aziga gave a rambling statement to the court, saying that he wanted to re-announce his Canadian citizenship and serve his sentence in Uganda or Kenya. He said that he does not accept that any reasonable person would conclude that he is in fact guilty in this case. If any reasonable person could conclude that he is in fact guilty of all conviction in the case against him, he thinks that same reasonable person would conclude that he would have been reasonably punished for medical condition. In 2010, Aziga filed a notice of appeal against his convictions and sentence to the Ontario Court of Appeal, challenging the trial judge's instructions among other grounds. The appeal was delayed for over a decade due to procedural issues and evolving other HIV non-disclosure cases. The 2 first-degree murder convictions were overturned in 2023, not because Aziga didn't do what he was accused of doing, but because the trial judge had given the jury incorrect instructions about what level of intent was required for murder under Canadian law. The 3-judge appeal court panel wrote that the dangerous offender designation should stand and that Aziga's sentence for manslaughter should still be life because of the gravity of his offenses. So the practical result didn't change much. He is still serving a life sentence. He is still designated offender, and he is still dangerous to the society. But the legal category of his offense shifted, and that shift carries real implications of how this case functions as a precedent going forward. The Parole Board of Canada denied Aziga both full and day parole for second time, citing concerns about his remorse and empathy sympathy towards the victims. Aziga continues to present as an undue risk to the society, as the board ruled in December 5, 2024 decision. He had been denied parole in December 2023, but on June 4, 2024 succeeded in appeal to have the decision reviewed. The decision review went ahead. The board reconsidered, and then they denied him again. It took a mere 10 minutes of deliberation for the parole board to reject Aziga's bid for release. The ruling noted that Aziga's behavior in prison has been generally obedient, aside from some recent concerns regarding his possession of large amount of explicit content and magazines. The board added that Aziga receives regular blood tests and medication, and the virus is currently undetectable. As of October 2025, Aziga remains incarcerated under his indefinite dangerous offender designation, with no additional parole hearing or legal challenges scheduled. The honest answer to most of the questions in this section is that they remain genuinely open, and the surviving victims, the people whose lives were permanently altered by what Aziga chose to do and by what authorities choose not to do quickly enough, have been largely absent from the record since the trial ended. The case produced a verdict. It never produced a reckoning. That is all for today's case and today's video. If you like the content, be sure to subscribe to the channel. I will see you in next case. Until then, goodbye and good night.